recording it, David, right?
I just started the recording, yes.
Okay, so you'll be able to make access to those that can't attend, and those that can attend, you might want to play it back again at some point, but we'll get the materials out to you anyways, so you'll have it. And just like last week, there's a fair bit of material to go through. So I'm going to share my screen, and David, if you just confirm that you're seeing the shared screen.
Absolutely.
Okay, assignments part 2. So welcome to part 2. And you'll see we divided this into 2 just because of the volume material. There's so many issues that have to be dealt with on these assignments. So last session, we focused more on the negotiations with the builder, agreement of purchase and sale, and restrictions on assignments and conditions imposed by builders, etc. Today, we're going to focus more on the assignment of agreement of purchase and sale, which is the document that's between the assignor and the assignee. So the assignor is the party that originally signed an agreement with the builder, and the assignee is the party that wants to take it over. So welcome to this, and there again is my pre-COVID picture. You guys all know about my firm. I'm not going to go into more of a commercial on that and what we do. I want to get right into this. You can find us at any of our locations. So let's get right into part 2. So what we're focusing on today is preparing the assignment agreement of purchase and sale. So I'm going to go through the issues that you're going to be dealing with that. And at the end of it, we've got a bunch of clauses here that you should find very useful as precedents to work from. There's clauses from an assignor's point of view, and there's clauses from an assignee's point of view. So you'll have those available to you when you're drafting these agreements. So when we're drafting the assignment agreement of purchase and sale, this will all sound very trite, and for the most part, you're sophisticated, experienced agents always doing a proper job, but it's always worth reminding people and mentioning again how important it is, particularly in assignments, to get all the information accurate and upfront. Proper names, full names, addresses, SIN numbers, ID, we need front and back, we need phone numbers, emails, name of solicitors that are acting on the other parties. It's really important to gather this all right up front. The builder's solicitor is going to need all this because we're going to them to ask them for a consent agreement, which, if you remember from last webinar that we did, that's the 3-party agreement that's going to be between the builder, the assignor, and the assignee, whereby the builder provides consent to the assignment, and there are certain conditions usually imposed on the assignor and the assignee as part of that agreement. So when we go to the builder's lawyer to ask them to draft that, we really need to have all this information in hand. Otherwise, it just slows down the process. And that's an important rule that the agents come in to make sure we gather all that information. So now when we get into drafting the agreement, and again, this is the assignment agreement between the assignor and the assignee. So there'll be a purchase price. So this is going to be a new negotiated purchase price. It's not the purchase price that was in the agreement of purchase and sale with the builder. So just for example, if you were buying a condo unit from the builder and the original purchase price was $400,000, but now it's being flipped on an assignment for $500,000. So we need that $500,000 purchase price is the price in the assignment agreement of purchase and sale. We also have to deal with deposits. There should be a deposit payable from the assignee to the assignor. So this is a new negotiated deposit in the assignment agreement, and it's not the same deposit that was originally given by the assignor to the builder. We're going to have to deal with that separately. But even if there's, let's say the example I gave, and there's going to be this $100,000 profit on the assignment, there should be some amount payable when the assignment agreement is signed as a deposit. And this would be dealt with just like any other deposit that you would have on a resale transaction. It would be going to the assignor's agent's brokerage, okay? In most typical ones. Sometimes it goes to a solicitor. There might be reasons for it, but there should always be a deposit when an assignment agreement is signed. Now, then we have to look at types of conditions that should be considered to go into an assignment agreement of purchase and sale. First of all, if you're the assignee, the party buying, you're going to want to see all the documents that have already been provided by the builder. You want to see the original agreement of purchase and sale between the assignor and the builder. If it's a condominium, you're going to want to see the disclosure documents that had to be produced by the builder. So you're going to want to have an opportunity to review it. So you need a condition on reviewing of those documents. It's really important on assignments to try and put conditions in, to make it conditioner on the assignor's lawyer to review it. If you're on the assignee's side, you make it conditional upon the assignee's lawyer to review it. And you'll see why, for those of you that haven't done one of these, these are complicated, and you're drafting these assignment agreements sometimes late at night, negotiating back and forth, and there's certain provisions that should be in or maybe shouldn't be in, and you're not sure. So at the very least, if you make it conditional upon solicitor review, even if it's for 24 hours, it'll give us an opportunity to go through this and make sure that the proper clauses are in there. You should also consider putting a condition on financing, just like you would in any resale transaction. You want to make sure from the assignee's point of view that you're going to be able to get your financing in place. And there's issues on assignments that come up on financing, and I'll talk a little more about that in a little while. And one condition that always has to go in is that it has to be conditional on obtaining the consent of the builder. Okay, and once this is done, that's when we go to the builder to ask for their consent and enter into that three-party agreement between the builder, the assignee, and the assignor. So all those conditions should be considered. Now you have to next look at some of the fees and costs that are provided. In any agreement of purchase and sale with a builder on new construction, there's certain costs that have to be paid to the builder in addition to the purchase price. So we have to make sure there's specific provisions in the assignment agreement that says who is going to pay for these costs. Will it be the assignor or the assignee? So starting point on this is we have to look to see what the agreement of purchase and sale says, because sometimes the assignment clause right in the agreement might specify that any consent provided by a builder will be subject to the assignor paying certain costs to the builder, or it might specify the assignee. More often than not, it's the assignor, but we want to see what that actually says. If it doesn't say something, then it's a matter of negotiation between the assignor and the assignee as to who's going to pay for what costs. So it's important to specify that right in the document. And if there isn't anything specified in the assignment agreement of purchase and sale, it's generally the assignor that's going to be paying those costs. Because most of the times when we look back to the builder agreement of purchase and sale, there'll be a provision in there that says any consent provided by the builder will be subject to certain costs being paid, and it's the assignor's responsibility because the builder doesn't know who the potential assignee is ever going to be. But oftentimes these amounts can be significant, so it's something that should be considered and negotiated in the assignment agreement itself. Now, the type of costs, one of the major costs that has to be considered is adjustments with the builder. Every builder agreement purchase and sale has certain adjustments that the builder wants to pass on to the buyer in addition to the purchase price. So it's got to be made clear in the assignment agreement that it'll be the assignee that's going to be paying all those costs and adjustments. And that makes sense because they would be paying it at the time of closing. The assignee is the one that's ultimately going to close the transaction with the builder. So those adjustments normally would go to the assignee. Okay, so if you're on the assignee's side, it's very important to review the agreement of purchase and sale to see, because there could be $10,000, $20,000, $30,000 or more of adjustments that have to be considered in addition to the purchase price. So it's important to take a look at that. Now, oops, I think I just skipped a page. Let me go back. We have to look at the closing date as well. Like, when is the assignment going to close? Is it going to close when we get the builder's consent? It generally can't close before that. So a lot of times from an assignor's point of view, an assignor wants to close as soon as possible. They want to get out of the deal. Basically, they want to get their money back. They want to get their profit. They want to close as soon as they can. We can't really close an assignment transaction until we get the builder's consent and that three-party agreement is entered into. So you've got to be careful in the drafting of it, because we've seen some that say, you know, as soon as we get the builder's consent, we close. But that doesn't make any practical sense, because we might get the builder's consent at 4 o'clock in the afternoon and we have no chance of closing an assignment transaction that day. So the clause should say that we will close a certain number of days after receiving the consent agreement signed by all the parties. So in here we put, you know, 3 business days. That, you know, that should be the minimum. You need, the parties just need time to get their money together and to get documents signed. So it should never be that we close upon receiving the builder's consent. Now, sometimes the assignment closing date is defined as the same day as the final closing with the builder, and that could work. It's whenever, because a lot of times that's a floating date. We don't know what that final closing date with the builder is going to be. It's usually a date specified in the agreement, but sometimes there's delays and that date gets changed. So we can have the assignment closing date to go along with whatever the final closing date with the builder, so it all happens at the same time. Now, as I mentioned before, from the assignor's point of view, they want the money. They want to close as soon as possible. So they want to close as soon as the consent agreement is done. From an assignee's point of view, an assignee generally would want to close when they close with the builder and close it all at the same time. If it's a cash deal, it may not matter to the assignee. They may have money available and they could close the assignment transaction at any time, at any time following the consent being obtained, because they're just paying a certain amount, that profit amount. They can pay it over to the assignor, and the assignment transaction is closed, and then the assignee will eventually close with the builder. But if the assignee needs mortgage funds in order to pay that profit to the assignor and the return of the deposit monies, if they need mortgage funds in order to complete the assignment, then the assignment transaction can't close until the final closing date with the builder, because they can't register their mortgage, get their mortgage funds until they close with the builder. So it all has to happen on the same date. So you have to look at it from an agent's point of view, find that out as well. Is it a cash transaction? We can get it closed as soon as the consent agreement is obtained. If not, we probably have to wait till the final closing. Now, I mentioned before the deposit, so let's go back to that a little bit. The assignee should be paying some sort of deposit to the assignor. This is different from the assignor's deposits to the builder, 2 different deposit issues. The assignor often has paid $50,000, $100,000, sometimes more than that to the builder. They want to get their money back as soon as possible. They want that refunded. And the assignee is going to get the benefit of those deposits when they close with the builder, because the builder's already received that deposit money. So on the statement of adjustments, the assignee will get a credit from the builder for that. But we've got to find a way to get that money back to the assignor's pocket. So the best way is, once that consent agreement is obtained, that's when the money should be payable to the assignor. So now the assignor's got their deposit money back. The problem again is the assignee may not have the money available to pay that. If it's $100,000, for example, they may not have that cash available. And if they have to wait for the mortgage funds, then there's no other choice. But you've got to make that clear in the assignment agreement as to the timing of the repayment of that deposit money as well. Now, the most confusing part when agents are preparing the assignment agreement purchase and sale is generally Schedule B. So I thought I'd walk you through this a little bit. So I'm going to see if I can zoom in. Can you read that at all there? I'm going to try and zoom in so you might be able to see it a little bit more.
It's a bit tough to read. Oh, there,
Yeah.
that's much better.
Okay. So
David, you'll share this with us, yeah?
yeah, it's all being shared, but I'll just
Okay.
try and zoom in a little bit on this. And this is a standard Schedule B that's part of every, like the AREA form assignment agreement of purchase and sale. So you have to complete these things on line 1, line 2, etc. And the language isn't clear, so I just tried to put a little bit more language in here. Like line 1 is the purchase price between the assignor and the assignee. So in this example, that's a $554,000 is the purchase price. So that's the price between assignor and assignee. That includes the profit that the assignor is getting on this assignment transaction. So then line 2, you complete it with what was the original purchase price, which is the price between the builder and the assignor on the original agreement of purchase and sale. So in this case, that was $518,900. So that's the amount that goes into line 2. So then line 3 is supposed to be the deposits paid by the assignor under the original agreement with the builder. So in this case, the assignor had already paid $78,585 to the builder. So that's what the builder has been holding. Line 4 is the deposit amount paid by the assignor by the builder plus the profit on this assignment transaction. So it's the total of line 1 and line 2. So it's the $78,585 plus the profit. In this case, there's a $21,100 profit. So that's the total of $99,685. And like I mentioned before, there should be a deposit paid on this transaction between the assignee and the assignor. So that's the amount that goes into line 5. So line 4 is the total amount that's going to be paid by the assignee to the assignor, which is $99,685. But when they sign this agreement, this assignment agreement, they're going to pay them $29,685. So the balance that's going to have to be paid is the amount that goes into line 6, which is the $70,000. So that's the amount that's still owed from the assignor, from the assignee to the assignor. And then it's a question of when it's going to be paid. The other thing that I just caution you about, if you can see paragraph line 3 in here, this is where you're talking about deposits, and you also have to fill in when the deposit is going to be paid. Is it going to be paid upon acceptance of this assignment agreement and receipt of consent from the builder? Is it paid upon occupancy of the assignee? Is it paid upon final closing? So that's got to be specified in here. You got to be careful with the proper dates being put in here as well.
David, what is usually the date that the balance is paid?
Well, again, that depends on whether or not it's a cash transaction or whether or not they're going to need mortgage funds. So it's a negotiated point. Again, from the assignor, they want to pay it as soon as possible, but the assignee says, hey, but I don't have that available to until I get a mortgage, so I can't pay that all to you right now. So something that has to be negotiated. It depends on the financial situation that the assignee is in at the time. If it's a cash transaction, like I said before, there's no reason why that can't be paid as soon as the consent is obtained. But again, you don't want it to say, like the language in here, you don't want it to say, they give you the fine print option is upon acceptance of this assignment and receipt of consent. But we can't pay it the second you receive the consent. So it really should be, you cross that out and you put, like it says here, as otherwise described in this assignment agreement, because you'll have a separate clause in there that'll say it's payable 3 business days following receipt of consent from the builder.
Mm-hmm.
Okay, so generally that's the option that I would tell you to choose. What we
but that's for the deposit. I was talking about the rest. So that's $70,000.
Yeah, well, that's $70,000 again. If it's a cash transaction on the assignment, that can be paid as soon as we get the consent of the builder or within a couple days after that. If the assignee needs their mortgage funds, then that $70,000 can't be paid until the final closing. Okay. And if it is at the time of the final closing with the builder, there's no reason why it can't happen the same day. It doesn't have to happen a few business days after you close with the builder. It really should happen on the same day at the same time that it's being closed with the builder.
Right.
Okay. And the 3 lawyers involved should be able to work that out. Okay. So let's go on to the next slide. And I know that previous Schedule B is confusing, and we see so many mistakes from agents on that. And that's why I wanted to give you an example and set it out. And if you're not sure when you're going through your first one, you're going to get in touch with your broker to help you. You're going to get in touch with me or the lawyer. If you've got a proper lawyer that knows how to handle these things, we'll help you through it, because that's where we see most mistakes on these. But again, I go back to the point I made earlier. If you can make it conditional upon lawyer review, that's going to save your bacon a lot of times on these things. So there's some other issues that you really do have to consider on assignments. If the assignment is happening on a condominium and there's an occupancy period, then the assignor has probably may have closed already and taken occupancy. Even if they never moved in, they've notionally taken occupancy with an exchange of documents, and they've provided post-dated checks already to the builder. So those post-dated checks would have to be replaced. The assignee's got to provide checks, and we want to get the checks back from the assignor. So dealing with checks sometimes delays the assignment process. So we always want to be on top of these things. We got to get them right away, because it could be a series of 6 to 12 checks in most cases. We want to make sure that the assignee, if they're taking over during the occupancy period, that they're going to be responsible for all costs. They'll be paying the occupancy fees and any other costs during the occupancy period. So we've got to make sure the assignee is basically stepping into the shoes of the assignor under the agreement. So they've got to take over responsibility if the assignment takes place during the occupancy period. Financing is a really important issue that we should be looking at. Sometimes the lenders will give an assignee a difficult time in terms of how much funding they're going to provide. And they say, we'll give you a mortgage, but we think that the value is based on the original purchase price in the builder's agreement of purchase and sale. And we want to just ignore the fact that you're paying a premium on this to take over this. So we want to lend you based on the value in the original agreement of purchase and sale, and not on the amount that you're actually paying to buy this property. So oftentimes this creates a big problem for an assignee, because they're going to be short funds. They may be expecting to get 75% of a $600,000 purchase price, because that's their assignment price. But the lender says, no, I'm only going to give you 75% of $500,000, because that's the price stated in the agreement of purchase and sale with the builder. And you go back and say, yeah, but that was signed 3 years ago and the values have gone up, and do a more current appraisal. And sometimes the lenders just say no. They have certain policies. So it's important to consider that right up front and find out if they're going to consider the fair market price or do a new appraisal, or they're just refusing to and they're going back to the original price. Because if they're doing that, the assignee may be short funds on closing. Now, control is an issue here as well. Once the three-party consent agreement is obtained, usually there's a provision in there that says, once, from the builder's point of view, once I consent, I want to deal only with the assignee and the assignee's lawyer. So we're going to give all future notices just to them. We're not giving the assignor notice or the assignor's notice. So the assignor loses control. So we've had situations where the builders have closed with the assignee, and the assignor, and sometimes that closing date gets moved around because of delays, and the assignee and the assignee's lawyer has no idea that the transaction closed, and we're not party to a three-party closing, and the assignor has not received any money, and we didn't know that the assignee's already received their mortgage funds, closed with the builder, and we're left in the dark. So that's why it's really important to have a clause in the assignment agreement of purchase and sale that makes sure that there's an obligation on the assignee to keep the assignor and the assignor solicitor aware of what's going on. Because usually the builder and the builder's lawyer are not going to do it. So we need the notices to be provided by the assignee and the assignee's lawyer. So they're not going to do that unless there's a specific clause in the assignment agreement of purchase and sale. And it's one of the clauses that we've got in the precedents that we're going to give to you. We don't want to allow them to close without us, because then they're already own the property. They've already got a mortgage on the property, and all that the assignor is left with to try and get their profit and the balance of the deposit monies repaid to them is a right to sue the assignee because they haven't received their money. So that's not a good enough position. I don't think you want to be explaining that to your clients as an agent, that you didn't protect them properly by having a clause in there that required notices to be provided, so we can do a three-way closing and make sure that the assignor gets their money. So that's a very important clause that has to go in there. And it's surprising sometimes. You think it's so basic, you'd think it would be something that would be in a standard form that a RIA would produce, but it's silent on that matter. So the assignee goes ahead, closes with the builder, and the assignor doesn't know what's happened.
That's why we have a relationship with you guys, David.
Thank you, because that introduces this next slide perfectly, David. Your timing's impeccable, and David hasn't seen this presentation, but he managed to do that. And this is our little commercial for you guys. So, but this is to show you what a lawyer's role really is, and our firm deals with assignments all the time. So we're there to provide assistance to the agents, preparing the assignment agreement, making sure that you've got these clauses and the proper clauses. And I'm giving these to you as precedents, but these always come with warnings, like anything else. When you put clauses in, you got to make sure that they're modified and they deal with proper issues, and sometimes it might get confusing. So we're going to give you two schedules that I'll go through some if we have time. One are just really drafted from an assignee's point of view, and that'll be in Schedule 1. We've got some other clauses from an assignor's point of view that are in Schedule 2. But the reminder that I'm giving you here is that these precedents are a starting point, just like any clauses you put into a resale agreement, purchase and sale. They always do require some consideration, some modification, some tailoring to make sure it applies. So don't just put them in blindly. Make sure you're thinking about it. You put them in and you modify them as required. If you're not sure, then you get some assistance, get legal assistance from us. We'll help you make sure you got the right clauses in. If you can't do it at the time because you're in the middle of your negotiation, then just get the one clause in that makes it conditional upon solicitor review. And then we have an opportunity to review it and get the appropriate clauses in before the transaction goes firm. Okay. Now let's just talk a little bit about the process for completing these assignments. On a resale assignment, even though my focus is more on new construction today, a resale, there's assignments as well that hopefully some of you will be doing and more comfortable for doing after you've gone through these webinars. So a resale is way more straightforward than new construction. The assignor solicitor will notify the seller solicitor, will get things done. The title is usually being directed from the assignor to the assignee as part of the closing, and there'll be a closing between the assignee and the seller. It's not nearly as complicated as a new build situation. The new build, there's more layers to it, mainly because we need the builder's consent that I've mentioned 10 times already, because that's the key document. So as soon as we get the assignment agreement signed between the assignor and the assignee, we have to immediately apply to the builder's solicitor to get consent. We got to get that ball rolling right away because it takes time. So the assignor's solicitor is going to have to determine if there's any fees that are applicable for consent, and the answer is there's always going to be some fees. It's really a question of how much, but we got to figure out what that is, who's responsible for paying that, and what checks have to be sent to the builder's solicitor. And there's usually a couple fees involved. One is a fee that'll go to the builder for providing consent, and the other is a fee that'll go to the builder's lawyer for drafting the consent agreement. So then we've got to get the builder's form of consent agreement, which their lawyer will prepare, and he'll send it to the assignee's solicitor, he'll send it to the assignor solicitor, and then the three lawyers have to go through it and make sure they're all protecting their parties and agree to it. There's information that has to be completed in that form, and that's where the agent's role is extremely important, to make sure we've got all that information that I talked about right at the beginning. Full names, dates of birth, SIN numbers, addresses for service, things like that. Who the mortgage lender is going to be. Part of the consent that a builder is going to, one of the conditions they want to consider, they want to make sure the assignee's got their mortgage financing in place and have an ability to close. We need all that information. We got to get it to the builder's lawyer as soon as possible. Okay, we need the assignee's solicitors, who that is. We need ID, etc. Anything that delays it could kill the transactions. We got to get that in place right away. Then we have to get the parties to sign the consent agreement. The assignor has to sign through their lawyer. The assignee has to sign it through their lawyer. We need the builder to sign the consent agreement with their lawyer. All three parties have to receive a copy of that agreement. And then that process is done, we're finished. And then like I mentioned before, the builder is finished with the assignor, doesn't want to deal with the assignor anymore from that point, wants to deal only with the assignee directly. The only time the builder is going to come back and deal with the assignor from that point forward will be if the assignee defaults on the final closing. Because one condition that will always be in these consent agreements is the builder will not release the assignor, and the assignor will only be released if the assignee closes. If the assignee doesn't close, the builder will still want to go back against the assignor as well for any damages. So now we've got the consent agreement. So the assignee has to go through two closings. They have to close with the builder. That's their first closing. So the assignee has now stepped into the shoes of the original buyer, the assignor, and they will receive the statement of adjustments from the builder, and we'll have all the closing documents to sign with the builder and mortgage documents to sign. And the assignee will complete the transaction with the builder and pay the builder the balance of funds due on closing. So that's one transaction that they have to close. The assignee also has a second transaction. They've got to complete the assignment of agreement purchase and sale with the assignor. So in this case also, there'll be a statement of adjustments prepared by the assignor's lawyer to send to the assignee, setting out what the assignment price is, how much of that deposit was paid, and what the balance is still owing. So we've got to have that. And there'll be a couple documents to sign as part of this transaction as well, which is basically dealing with the flow of funds and the adjustments that have to be paid. There's not a lot of documents, but there are a few documents that should be signed as part of this closing as well. And one of them is an undertaking to readjust. So we just make sure that the parties adjust for the appropriate amounts on closing. And then that'll close by the assignee paying the assignor whatever is owed, which would include that profit amount under the assignment agreement and any further repayment of deposits. Now, why do assignments get in trouble and often die? And these are important things to consider because it happens quite often. And as you know, as real estate agents, you only get paid on successful completion. So if your assignment transaction dies, you're not getting paid your commission. So you've gone through an awful lot of work to get an assignment agreement of purchase sale completed. You've gone through an awful lot of work to review the original transaction with the builder, and we've got a consent agreement done. And sometimes these transactions fall apart somewhere along the line or at the end. So it's worthwhile just going through some of this. One of the reasons they die is because either the agent or the lawyer didn't do a proper job of explaining this process. It's complicated. There's a lot of moving parts on these assignment transactions. So there's the fear of the unknown. So as I point out here, it's important to have a good agent and a good solicitor. That's the key. But a great agent and a great solicitor is even better because you need to inform the clients, whether you're acting on the assignor side or the assignee side, they have to know what the potential issues are, what to look out for. And it's your role, my role, to make sure that this is all explained to them. And we're a team in doing that. That's the way we approach it at our firm. You and I, you as an agent, me as a lawyer, we're a team acting for the same client and helping them through this complicated process, but it's a worthwhile process because they can make a nice profit on this if they're an assignor, or it's an opportunity for an assignee to buy a property that they otherwise couldn't get because the inventory from the builder might be gone, but now here's a chance to buy it. So you're providing a very important service, but let's do it the proper way. Timing's another issue. The assignor always wants to get their money all up front as soon as possible. Sometimes the assignee says, well, I just can't give it to you. I need my mortgage funds. Sometimes the transaction dies because the assignor says, well, I can't wait till the final closing. I need my money sooner than that. So I'm going to go look for a different assignee that can close this on a cash basis and get it earlier. Another reason these things die is because the builder consent isn't received. Sometimes it's just because the information wasn't provided in a timely fashion to allow the builder and their lawyer to prepare the consent agreement. They get frustrated and they say, you know, we're not dealing with this anymore. That's why it's really important, as I said right from the outset, to gather all that information up front. So when we're going to apply for the builder's consent, we want to make it as seamless as possible for them so that we don't give them an excuse to say no. The issue of the assignment fee itself can become very contentious. There's almost always a fee that the builder is going to charge. We've seen these fees go from, as I mentioned in last week's webinar, anywhere from $2,000 to $3,000 up to $50,000 just for the builder to provide a consent. So you can imagine if you drafted an assignment agreement of purchase and sale that was silent on who was going to pay an assignment fee to the builder, and the builder says, yeah, I'll consent, but it's $50,000. And at that point, you've got to negotiate who's paying that. Is the assignor or the assignee? And they're going to turn to you right away and say, why wasn't this discussed and negotiated right up front? So it's important that gets right into the assignment agreement of purchase and sale. Whose responsibility is it going to be? And oftentimes, you know, you're making that negotiation when we don't know what the amount is. And it's one thing if it's $2,000 or $3,000, that's an easier issue to resolve, because, you know, one party, you know, if there's a nice profit, the assignor is often very happy to pay that $2,000 or $3,000. If it's a larger amount, it's really something that should be negotiated out. We find these die sometimes because we don't have enough information from the assignee, so we don't get the consent turnaround in time. F, advertisement. I mentioned this last week in the webinar for those of you that were on it or those that want to go back and take a look at it. Usually the consent that we get from the builder says, I'll consent to the assignment, but you can't list the property in any multiple listing service or in any social media, and they tie your hands up. So you can't advertise it. So what happens if someone goes ahead and does advertise it? The builder's lawyer sends a nasty letter saying you're in breach of the agreement of purchase and sale because you advertised it on FaceTime or MLS or WeChat or wherever you did it. And the agreement's at an end and we're keeping all the deposit monies, et cetera, et cetera. So oftentimes we come back and say, you know, don't terminate us. We will agree not to advertise it anymore. And please don't take away our deposit and sell it to somebody else. And we agree to cooperate and behave. Sometimes the builder will say, well, fine, we're not going to terminate you, but we're not going to allow you to go ahead with any assignments. So that just blew your assignment transaction. So the builder is taking a hardline stance saying, I'll still close with the original assignor, with the original buyer, but I will not consent to any assignment transaction because you breached the advertising clause. Another issue that I mentioned earlier is financing, and from an assignee, you want to have it conditional on financing, make sure that's in place. But sometimes the assignee gets in trouble in terms of getting their financing or getting enough financing. And by that, it's the situation I mentioned earlier where the assignee is expecting financing based on the assignment purchase price, but the lender says, no, I'm only going to give you financing based on the original price with the builder. So now the assignee has a shortfall and is scrambling to make it up, or the deal dies because they can't get it. HST is a big consideration on these assignment transactions, as I went through in part one of the webinar last week. And especially dealing with the HST new housing rebate. If the assignor, the original buyer, didn't originally qualify for the new housing rebate and provide evidence as part of the assignment transaction that they would have qualified, then the assignee may not qualify. So it's really important to determine whether the assignor would have qualified or not. Sometimes on assignment transactions, one of the conditions is when the builders can provide their consent, they're going to say, yeah, we'll consent to your assignment, But we don't want to look into whether the assignor would have qualified, whether the assignee would qualify for the HST rebate. So we're consenting, but we're not going to give you a credit for the new housing rebate on closing. And you have to, the assignee is going to have to pay an amount equal to that new housing rebate in addition to the purchase price on closing. And then it's up to the assignee to apply after closing for that rebate. And whether or not they get it will depend on whether the assignor would have qualified for it as well. And you'll see in the precedents that we gave you, there's precedent clauses to put in there where the assignor will be providing a representation and a warranty that they would have qualified for the HST rebates. We want that to be put in if you're on the assignee's side, because that's an important thing to put in there, because without that, the assignee is not going to be able to successfully get the new housing rebate from the government. HST itself is an issue, and one of the reasons why these transactions die sometimes. And the HST is different from the HST new housing rebate. Here I'm talking about HST on the profit. The government's going to charge HST on the profit that the assignor is making. So the assignor has to be aware of that. And there has to be something in the agreement of purchase and sale that says that the assignor is going to be responsible for that HST. Or it could be a negotiated point, and it could say that the assignment price does not include HST, and the HST is actually going to be paid for by the assignee. But somebody is going to be paying that HST to the government. So again, that has to be negotiated up front, or there's a good transaction that could be a good possibility that that'll be a deal killer down the road, because all of a sudden somebody's got that HST obligation. As I mentioned last week, CRA is even more aggressive on the HST. It's very clear they want HST on the profit, but CRA has taken the position they also want to charge HST on the deposit amount that was originally paid by the builder to the builder by the assignor. So it's an HST money grab, and that could be a more significant amount. So again, that could be a potential deal killer. So we've got to make sure that's covered. Occupancy costs, who's paying for that? It's got to be specified in the agreement of purchase and sale, or it could kill your deal. Is it the assignee or the assignor? Who's paying the other adjustments with the builder? It should be specified. Like I mentioned earlier, it's going to be the assignee in most cases, but it's got to be clear in the agreement because that could be a $10,000, $20,000, $30,000 amount. So that could kill your deal as well. Incentives is something that we haven't talked about yet. A lot of times builders are providing certain incentives on new construction projects, and it could be something like they're providing certain appliances on closing. It could be a TV that they're providing. Sometimes on a condo project, it might be that they put as an incentive that they'll waive the first year common expenses. You won't have to pay common expenses for 1 year or something like that. There might be a schedule or provision in the original agreement of purchase and sale that provides one or more of these incentives. You've got to be very careful. A lot of times in the language, it specifies that that incentive will only go to the original buyer, and that if an assignment takes place, the assignee is not going to get the benefit of those incentives. So we've got to make sure that's clear. Sometimes the incentive will only go to the assignor, and the assignor wants to get paid that. That's got to be specified as well. Who gets it on closing? If it's not specified, it's a potential deal killer. Okay. Even something as simple as, you don't have to pay your monthly common expenses for the first year after closing. And then you read further in the document, it says, but this is only applicable to the original buyer. Okay. So you're not doing your job as an agent. I'm not doing my job as a lawyer if we don't find that and point it out to them. And maybe if it does specify that, then that's something that we might want to raise when we're negotiating the consent agreement, because maybe we can get the builder to waive that and allow those incentives to be applicable to the assignee as well. Another point is delayed closing compensation, especially in condo projects. Oftentimes they start building these things 2, 3, 4, 5 years after the original agreement is signed. things happen, there's strikes, there's delays, there's even COVID. Things come up unexpectedly, there's delays. At some point, the buyer from the builder is entitled or might be entitled to delayed closing compensation. It's got to be specified in the agreement of purchase and sale that if there's compensation coming back through Tarion, who gets it? The assignor or the assignee? Silence on these documents or absence of clauses is never your friend as an agent. It's never your friend as a lawyer. It's what gets us in trouble. So we've got to, you're going to use these things as a checklist, hopefully going forward, and make sure that your deals don't get killed. In the remaining time, I just want to show you some of the clauses that we've put in here in Schedule 1 and then Schedule 2. So you've got these as precedents. So Schedule 1 is clauses that should be considered for assignee. And please don't just blindly throw this, these couple pages of clauses into any assignment agreement. You've got to give it some thought and consideration. Sometimes there's conflicting provisions in these precedents. So just be careful when you're doing them. If you're not sure, get in touch with me or one of the lawyers in my office, and we'll help you through it. We've got some people that are in our office that are extremely experienced on assignment transactions, both at the lawyer level and we have some clerks that are fabulous with it. I can tell you honestly, we have some clerks that don't want to go near this. They don't want to do any assignment transactions because they find it so confusing. And it is until you work through it. So we sort of use certain clerks within our office when we're involved in assignment transactions, and they understand the issues. They've gone through this process, and they know it as well as the lawyers in my office know it. You'll run into difficulty with other law firms because we do as well. There's certain law firms that'll just say no to any assignment transaction. They don't want to do it. Just like there's certain agents that'll just say no, they don't want to do it. It's confusing. You're prone to making mistakes, and some just don't want to do it. So my advice to you always on these things: if you're going to do it properly. Take the time to educate yourself, to understand the process, do it properly. Make sure the lawyers involved are doing the same thing and they can handle it. So anyways, back to this clauses from an assignee's point of view. The first one is whose responsibility is it to pay the assignment fees. Okay, so this would make it clear that it's the assignor's responsibility. There's a similar clause on the assignor precedents that'll say it's the assignee's responsibility, but it's got to be specified one way or the other. We want the assignor to be assigning all the rights to the assignee. So the second point here, the second clause here is making sure that they're going to sign all the rights. So they're signing the rights to the deposits, they're signing rights to any amounts paid for extras. We want them to give all benefits and credits to the assignee. And the right to purchase the unit. So a clause like that should go in there. The next one is the one where I mentioned earlier that the assignment closing should be 3 business days at least after getting the consent. So there's the actual language that you should be putting in there. The middle one on this page is an assignor agreeing to indemnify the assignee for anything arising under the agreement, because we're relying on the assignor that their deal is in good standing. They're selling us their agreement of purchase and sale. So we want them to tell us that everything is in good shape, and they're providing an indemnity to the assignee. And the third clause on here is a representation and warranty with respect to it, that it's never been leased out, it's never been occupied before, it's been vacant until closing, and that they'll provide a declaration on closing supporting that. And that's really important, especially when it comes to the HST new housing rebate. We have to know that the assignee is going to be the first person occupying that property. So we only know that if the assignor provides us with a declaration on closing and a rep and a warranty that they didn't occupy it. Otherwise, we're not going to just take their word for it, and the government's not going to take their word for it. But the assignor is not going to provide you with that information unless you have a clause like this in your assignment agreement of purchase and sale. Okay, you may need a clause, make it conditional upon so many business days. Anyways, I don't want to go through all of these clauses, but I want you to just see that there are these clauses in here. Now, I want to point this out. If the assignor happens to be a non-resident, it creates an issue under Section 116 of the Income Tax Act. So these are clauses that should go in if your assignor happens to be a non-resident. So if they are non-resident, then the monies that's going to be payable to the assignor are subject to the holdback provisions in the Income Tax Act. So it's important that that you get a clause like that in there, so we have the right to require the assignor solicitor to provide an undertaking that they'll be holding back funds so that they comply with the Income Tax Act and obtain a certificate of compliance before monies are released to the assignor. So without having a clause like this in there, we don't have the right to require that on closing. And this is very important because although it's the tax liability of the assignor that is the subject of the holdback, if the assignee doesn't make sure that there is a holdback, the liability to the government can go to the assignee instead of the assignor. And I know this is probably confusing, but it's a really important point that we get that. So we have proper holdback language put in there. So there's some precedents in here, and we'd certainly help you through it. Some other more basic provisions just to run through. We want to make sure that the Terrian insurance provisions and warranty provisions are passed on. So we have to get the assignor to assign their rights under the Terrian warranty program to them. And that goes along with rights to compensation and things like that. So, you know, that's the insurance protection that is provided originally to the buyer, who is now the assignor. We want to make sure that the assignee gets the benefit of all that coverage. Okay. There's a clause here. The last one on this page deals with HST payable on the premium, which is the profit amount. Whose responsibility is it? Is it going to be the assignor's responsibility to pay that HST or the assignee? So obviously from an assignee's point of view, we want to make sure it's the assignor. Certain representations and warranties that we want. And that's in terms of, you know, the assignor saying that they've completed, you know, picking their colors and upgrades and purchase orders and things like that. We want to see that, and we want a rep and warranty from them as to what that is. We want to know that the original agreement's in good standing, that they haven't been in breach of their agreement purchases of their agreement. What if they've already received a letter from their from the lawyer saying they breached the agreement purchase and sale because they advertised? So we want to know about that. So we want these reps and warranties in there as well. So there's a couple examples for you. We've thrown in some conditional clauses here, which are standard type of conditions on so many banking days. We put 5 banking days in here, you know, for getting, you know, confirmation of various things. And there's nothing magical about these conditional clauses, just in terms of the language that it's talking about assignor and assignee instead of the language that you're probably used to, which is talking about seller and buyer. Pre-delivery inspection should go in there too, because we want to know if the assignor has already completed their pre-delivery inspection with the builder. So if they have, we need some information on that, and it has to be passed on. So in the remaining couple minutes, we'll just flip through. Schedule 2 is just clauses on the other side when you're on the assignor side. And a lot of these clauses are similar in nature, just putting the obligation on the other party. But we want to make it clear, and the language is turned around from an assignor's point of view. So I don't think there's anything in here that I specifically wanted to point out to you. We'll run through that. But it's sort of turning these clauses around. Anyways, I want to end it here because I want to leave a few minutes for any questions that you have. I'm pointing out to you again, our offer is open for any frontline workers that you know, 25% off. And thank you very much for attending. I think we're pretty close to 12:30. So I'm going to throw it back to David and Sabiha, and any questions that you might have for me, I'll be happy to answer.
Anybody have any questions for David Korman? if you guys want to go ahead and unmute yourself and ask any questions, lots of materials covered.
David, I know. Oops, hearing the back. In your first session, you had mentioned, and I think that's and a couple of questions are kind of regarding that too. Is that you can, when you're purchasing initially the pre-construction, and there is an assignment clause which allows you to do an assignment. At that time, you can also consider seeing what the assignment fee might be. That the builder is asking for, and if you do that at that point, then when you actually do end up assigning the unit, you know, it clarifies and eases the process.
Yeah, absolutely. You know, that's an opportunity to try and pin them down as to what their fee is going to be. So at least there's some certainty, and it might be 3,000, it might be 5,000, whatever it is. At least you know what it is, so that you know when you are later on assigning it, you've got to take that $5,000 assignment fee into consideration, because if the assignor is paying it, then they're actually, you know, their profit's going to be $5,000 less than they thought it was going to be. But it might be a negotiating point that you can pass that cost on to a future assignee and say, hey, you know, I'm happy to sell you this unit. You take over my position, but assignee, you're going to have to pay the assignment fee to the builder, which I pre-negotiated, and it's $5,000. So you have to pay that. So
and that's why it's, guys, so important and imperative that in the 10-day cooling period, when you actually get the initial documents and everybody's excited about that deal, is to go take it to the lawyer and actually show it to them, so that if there is an assignment clause, they can point out this thing to you that, you know, possibly put in an approved amount of assignment fee in there.
Right. And by taking it to your lawyer, I think you meant to say by taking it to Korman's LLP.
Korman, absolutely. That's always what I'm saying. There's another question from Laura that the resale assignment is like any other resale sale, and it's not, Laura. This would be, you know, the difference between a regular sale and an assignment sale is that this is pre-closing. Right, so the title is not being transferred into the new purchaser's name, and this is in the interim period between the deal being accepted and the closing date, that you are assigning that deal to someone else. David, you can clarify it if you like. Laura, are you good with that? Hello?
So as we see more pre-construction sales happening, as inventory continues to be really scarce out there, I think we're going to see more assignment sales coming on the market. And remember, banks are changing their pre-qualification criteria. So a lot of people have bought pre-construction, might be in a position where they can't close them. So this is where assignment sales really play a big role. So I think becoming more familiar with the terminology, with the process, with the procedures, and with the pitfalls that David Korman's office has pointed out, you know, I think it's going to empower all of us to be more comfortable and confident with these moving forward. So David, thank you very much for taking the time going through these with us. I know I've learned a lot myself. We do have a recording of both these sessions that we will be sharing with everybody, so you can reference them as well.
Yeah, and we're going to be asking David to share his schedules and his clauses so that we can actually add them to our brokerage clauses. But everybody, please make sure that through the 10-day cooling period, don't ignore the fact that you do have a great lawyer partner, and do share your client's documents at that time, because once everything is signed and done, and then issues come into play, and then you're like, oh, I wish I had done it. So, you know, go ahead and discuss it with your lawyers beforehand.
Yeah, well, thank you. And we will send you out all the materials, and you could pass that on. And I think David's point was well made. And something that's come up, you know, because we're in a COVID situation too, there was a lot of builders that were reluctant to consent to assignments before, and a lot of them have relaxed their position more recently because they know that they had some bona fide people that bought and intended to live there themselves. And some of those have just lost their jobs. And even though they pre-qualified for mortgages and things like that, and they would have closed, but now they're just in a different situation. All of a sudden they can't close. So the builder's left with two choices. One is they can just sue the original buyer, put them in default, and then put the property back on the market. But another option for them is to allow an assignment to go through. And it's a reasonable position for them to take right now. As much as they hate assignments, they'd rather go through an assignment transaction than go through a lawsuit in trying to, do battle with the defaulting buyer and then still have it to sell the property again themselves. So a lot of them are a little more open to assignments now than they used to be, which is why I think it's great that Dave and Sabiha are putting these webinars together for your office and encouraging you to learn how to do them and get them done, because it could be a great way for you to earn some more commissions, because I think you're going to see more of these out there, and you got to know how to do them and do them properly, and those should be good business for you.
Excellent. Well, Dave, thanks again for taking the time and helping educate us. And as always, we're happy to rely on your expertise.
Okay. Thanks for having me.
Have a great day.